Hello everybody. In this session, we will be discussing on right to privacy and the current affairs that is related to this particular topic. But before we move on to the current affairs, we need to have an idea about certain basic terms. So let's begin with what do you mean by the term privacy? Now privacy as a term is a very subjective term. It has quite many definitions, but then in general sense you can say that privacy is the ability of an individual to be left alone or express themselves selectively. That is, to be left alone as well as express themselves selectively. And then again, we will move on to what do you mean by the term information privacy. Now, information privacy gives you the right to have some kind of a control over how your personal data gets collected as well as used. That is, it gives you a control over how your personal data is being collected as well as used. So that is all about this information privacy. Now coming to the current topic, that is right to privacy. Now what do you mean by this term right to privacy? Privacy is a legal framework, and through this legal framework an individual gets the right to protect the privacy of himself or herself as well as their data. That is, right to privacy is a legal framework that provides the individuals a legal right to protect their as well as their data's privacy. So this is what you mean by the privacy, information privacy as well as right to privacy. Now we'll look into what is exactly the status of this right to privacy in India. So since the right to privacy has not been mentioned explicitly in the Constitution, it has been defined through various judgments. Now, when you come across or when you look into the relation that the right to privacy has in relation to that of the fundamental rights, there are two judgments that are very important from this relation. That is, the first thing is in 1954, the MP Sharma versus Satish Chandra case, as well as second in 1962, Karak Singh versus the state of UP case. Now the first case was judged or was adjudicated by an 8-judge bench, as well as the second was determined by a 6-judge bench. Now both of these judgments gave the verdict that right to privacy is not a fundamental right. So the judgment was right to privacy is not a fundamental right. What exactly the current affairs is all about? Before looking into the current affairs, we look into what is the background that led to this particular current affairs. Now we are all aware about Aadhaar. Now Aadhaar is an Aadhaar project is wherein you are being given a 12-number unique identification number, and it also, and as a part of the project, your biometric data is also being collected. So initially the government made Aadhaar mandatory for availing certain services or welfare schemes. But then gradually government started making it mandatory for availing numerous services as well as welfare schemes. Now at this particular time, a bunch of petitions went to the Supreme Court, and in the petitions it was argued that the collection of the biometric data was seen as a breach of privacy. So this petitions was being taken by the Supreme Court, and the case was going on between Aadhaar as well as a privacy breach. Now during the hearing, the sender argued that right to privacy is not a fundamental right. So at that time, a question arose whether the right to privacy is a fundamental right or not. So this bench referred this case to another bench, but then what happened is we already have in MP Sharma case the 8-judge bench deciding that right to privacy is not a fundamental right. So to look into this aspect, a numerically superior bench was required, and that led to the setting up of a 9-judge bench, and that recently gave its verdict last week. So we look into what the verdict is all about. Now the case is also called as K. Puttaswamy versus Union of India, and in this case what the Supreme Court unanimously, that is a 9-bench unanimously gave the verdict that right to privacy is a fundamental right. So right now, right to privacy is a fundamental right, and it has overruled all the previous judgments that were already existing, be it in 1954 or 1962 case. Now it is right to privacy is a fundamental right. Now we look into what exactly the judgment said about the right to privacy. the judges noted that right to privacy is an integral part of Article 21. Article 21 that provides or that guarantees an individual right to life as well as personal liberty. So the judgment noted that right to privacy is an integral part of Article 21 and also can say that right to privacy is intrinsic to the Part 3 of the Constitution that deals with the fundamental right. And then again, the court also noted that right to privacy, it means that that the individual has the right to be left alone, and it also meant that the individual had the right to make his or her own decisions. So decisions, for example, it meant where you live or what you do, who are your partners, as well as even to the extent of deciding your sexual orientation. Such things were being brought into. That is, so what the judgment said is that right to privacy is an integral part of the Article 21 and it is intrinsic to the entire fundamental rights chapter of the Constitution, and also right to privacy meant at the core the preservation of the personal intimacies, sanctity of the family life, marriage, procreation, home, and even to the extent of sexual orientation. So this was what was said in the judgment. Now more was said. In this judgment, it was also noted that three elements form the core of the right to privacy. Now what are these three elements? The first thing is the personal autonomy. Second thing is the freedom to make choices. Third thing is with respect to the right to determine. Right to determine means right to determine what your data will be used for, and you will have a control over your data, which in turn means information privacy. So it was said that when you summarize all the judgments, you can say that three elements lie at the core of right to privacy, that is a personal autonomy, freedom to make choices, as well as information privacy. Now this was the judgment, and then again the court also mentioned that right to privacy is a fundamental right, but at the same time it is not an absolute right. That means it is subjected to the reasonable restrictions that is mentioned, that is applicable to the fundamental rights. And also the court noted that there has to be a balance between the right to privacy as well as the legitimate interest of the states. Now what do you mean by this legitimate interest of the state? It can be public interest, national security, you have the criminal investigation, you have provisions for promoting the innovation, or if it is to prevent the leakages of various welfare schemes. These all can be seen as a legitimate interest of the state. The court noted that there has to be a balance between the right to privacy as well as the legitimate interest of the state. Along with it, the court, by not providing any particular limitation to this particular right, has continued its approach of developing a right case-on-case basis. So the judgment noted that right to privacy is not an absolute right and a balance has to be struck between the individual interest as well as the legitimate aims of the state, and also it maintained its approach of developing a right case-on-case basis. So this was what the judgment was all about. But again, we can say that this recently passed verdict, that is right to privacy, is a landmark judgment to India. Now why it is a landmark judgment to India? Now the right to privacy is recognized in different countries. It is in United States, it was recognized as a part of the 4th Amendment Act of the Constitution. In Brazil, it is an inviolable act and inviolable right. And in countries like Canada, Australia, the right to privacy has been protected through legislations. But then in India, the recognition of this right to privacy as a fundamental right is very important, because in the judgment, the judge noted that the right to privacy cannot be denied even if it is a minuscule fraction of the population getting affected. So what the court has done is that it has protected the heterogeneity of the country as well as recognized the plurality as well as diversity of the country, and thereby reinforce the beautiful principle of India, that is unity in diversity. So this judgment is in fact a landmark judgment for India. Along with it, it has also brought in various implications. Now what are the implications? As I've already said that it is the Aadhaar case that have led to the determination of whether right to privacy is a fundamental right or not. So first of all, its implication will be felt on the ongoing legal case on Aadhaar. Now in Aadhaar case, the court will have to look in the light of the recent judgment, that is right to privacy is a fundamental right, and the government will have to convince the court that the Aadhaar initiative comes within the reasonable restrictions that are allowed for this right to privacy. So that is one thing. And the second thing is that it is bound to affect the various government initiatives. For instance, it is the DNA profiling bill that was recently tabled, and though the bill aims at standardizing as well as regulating the DNA test, it has certain privacy related issues like whether the confidentiality of the DNA is being looked into, and how it is being stored and how it is being handled. Such kind of issues will have to be addressed. And along with it, there is a smart city issue, that is smart city as well as other Internet of Things related aspects, which collects the personal data of the customers and gains insight to the customers. Such kind of initiatives will also be affected, and the legality of such kind of initiatives will be checked on. And then again, you have the section 377 coming in. Now basically, the section 377 of the Indian Penal Code looks into, or it mentions about the criminalization of the homosexuality. Now the Delhi High Court had earlier decriminalized the homosexuality, but it was in the Kaushal versus the Nas Foundation case that the Supreme Court overruled and reinstated the validity of the section 377. But now, since the right to privacy has been made a fundamental right, and also the right to privacy includes your sexual orientation also, the legality or the validity of the section 377 will have to be reviewed. Now that is the next aspect. The next will be on the pending lawsuit over the social media data sharing. For instance, it is the ongoing case wherein the WhatsApp has been sharing the subscriber data to its parent company, that is Facebook. So that is a case that is going on. So that will be affected since the privacy has now become a fundamental right. And along with it, this is not only going to affect this particular lawsuit, instead it will also affect all those corporates who have been involved in the data sharing practices. So that is also going to get affected by the right to privacy verdict. So apart from that, even the societal issues like the marital rape as well as abortion will now be reviewed, and its legality will be looked into, because now the right to privacy has ensured the right of a woman to her bodily integrity. So that is another aspect, and along with it, it also gives the right to a citizen to choose one's food. So these are all the implications. That is, in short, you can say that this particular right to privacy verdict is going to have implications over your Aadhaar legal case, and then your section 377, its validity will be reviewed, and then again the e-commerce as well as various applications, or what you call it as apps, will be affected, or since they collect your data, now that will have to be looked into, and then it has implications on the choice of one's food, and then again on the social issues like the marital rape as well as abortion, and then even to the government initiatives like that of the DNA profiling as well as the smart city, such kind of initiatives. So these are the implications. When you look into the right to privacy judgment, we can see that this particular verdict puts on both a positive as well as a negative content on the state. That is, positive as well as a negative content. Now what is this negative content? Negative content means the right to privacy has put in a restraint over the government's initiatives that intrude into an individual's privacy. That is, it is restraining. So that is a negative content. Now when you say what is a positive content, is that it has also put an obligation on the state to ensure that the privacy of an individual is well protected. So that is, one is restraining, that is the negative content is restraining an individual, while the positive content is putting an obligation on the state to ensure that the right to privacy of an individual remains intact. So for that, what the court had noted is that we need a data protection law. A data protection law that can ensure that what exactly is being done with the individual's data and how it is being stored and such issues. So that calls for the need for a data protection law. Now this data protection law has to be in such a way that it protects an individual even from the non-state actors, that is including the corporates. So the data protection law has to protect an individual from both the state as well as the non-state actors. But then again, we have present law, that is Information Technology Act of 2000, that is looking into the privacy related issues. But then again, it is in 2000 and it got amended in 2008. But then again, it falls short of updation. Now what happened is that it has certain categories like that of the sensitive personal data, but then again it is very limited. So that is the first aspect. Second thing is in relation to the section 43A, that is it covers only the corporate bodies and excluding the government agencies which have to be included in this present era. So that is the second thing. Third thing is with respect to the section 72A. Now the section 72A puts an onus on the petitioner to prove that not only a breach of privacy has been occurred, but also he or she has undergone a loss by this particular activity. So such kind of provisions are there in the IT Act of 2000. So what needed is a strong data protection law. Now a draft or a sample or a model data protection law can be the recently developed UK Data Protection Bill. Now this particular bill aims to substitute the Data Protection Act of 1998. Now there are certain provisions in this particular bill that can be included in our much needed data protection law. Now what are they? The first thing is that it grants users more control over the data, as in how one's data is being used by others. So it grants users more control over the data. That's the first thing. Second thing is that it also has included the right to be forgotten. Now what do you mean by this right to be forgotten? Right to be forgotten means that the user now has the right to ask company or even the social media companies to erase data of a particular individual. So that is with respect to the right to be forgotten. Now that is being included in the Data Protection Bill of UK. Then again, the personal data, the items that is coming out of the personal data has been made wider. Now wider in the sense that it has included certain provisions or certain items like the IP addresses, then you have the internet cookies being added, and also you have even the DNA being added under this personal data. So that is how it is being updated. And then again, you have the tougher punishment. If a particular company or an entity fails to comply with the guidelines as well as to store the or properly handle the data of an individual, then there will be tougher punishment, much severe than what is present in India. So these are the various provisions that can be included in our much needed data protection law. So what are the recent initiatives that have been happened in this regard? The first thing is with respect to the assurances that has been given by the Minister, Union Minister of Law as well as IT, that a data protection law will be developed and it will be tabled in the Parliament by the December. So it will be in compliance with that of the recent Supreme Court judgment that the right to privacy is a fundamental right. And this particular law will be developed by an expert committee that is being headed by the former Supreme Court Judge B.N. Sri Krishna. So these are the developments that are being occurred in regard to the data protection bill. Now the need is to ensure that the right to privacy remains intact as a fundamental right. And for that, certain responsibilities are there upon the executive, legislature as well as the judiciary. Now the legislature as well as the executive have to see to it that no policy or a law that completely takes away the privacy from an individual is being introduced, and also the judiciary has to see that the right to privacy as a fundamental right has to be balanced with the other fundamental rights like that of the right to free speech or the others like the right to information. Now the balance has to always be struck. That's the first thing. Second thing is that we need to have a stronger privacy policy. A privacy policy in such a way that there is assurance to the users that their data won't be used without their consent, and it will be used only for the purpose as well as to the extent that they give the approval. So it has to be a stronger privacy policy. Along with that, we need to have a stronger cyber security for which more investment is required. Only when there is in place a strong privacy policy as well as a cyber security, can the initiatives that come under the umbrella of Digital India will be satisfied, or it will be successful. And then you need to have a mechanism, that is regulatory mechanism. For instance, a regulatory authority, an independent regulatory authority can be set up, and that will be directly accountable to the Parliament, and it will look into the handling of the data issues and will be responsible for any kind of mishandling. So these are the various aspects that can be included, that is the responsibility of the executive, legislature, judiciary, as well as a stronger privacy policy, as well as a stronger cyber security, as well as a proper regulatory mechanism. So these are the main things that can be included to ensure that the right to privacy remains intact. Most of all, the need is that in this digital era, there has to be a balance struck between the technological advances as well as the right to privacy. Now these are the main things that are associated with the right to privacy. I hope you've understood it. Thank you.